Good afternoon, everyone, and welcome to this year's information session. Today, I will partly be the host, and we also have other editors who would be helping us with the same. My name is Colin Soko, and I am the editor-in-chief for the 7th volume. And I think just like the Igbo adage says, when the journey is so successful, you would want to exploit again. I'm saying this because this information session started last year, and it started together with the inaugural Yashinji Cultural Guy Writing Prize, of which I would like to congratulate once more the winner of that prize in absentia, Miss Michelle Kangethe. It was a job well done, and I encourage all of us to go take a look at the article as well. So it's my pleasure today to state that despite the information session starting last year and being limited to the Kenyan jurisdiction, this year we expanded the scope. And I think it's an honor to mention that today we're hosting over 11 countries, being represented by the people who registered, and the number of registration being commensurate to the number of attendees that we have today. So this is a huge success to the Strathmore Law Review. And this is also a huge success to the founders, the other partners that we have, the SUP and every other person, because now this has shown us that more and more authors are getting interested in legal research and writing. And, the Strathmore Law Review is also making success in that same avenue. So that's good news, and that's great development on our own part. Today, allow me to start with the purpose of this information session. So this information session was brought about because of three main purposes. The first of all is that we noticed that Africans can think, or authors can think, students can think, but sometimes they don't really have the tool to, engineer social change. And this tool is, include things that are critical to legal research and writing. And this comes in hand comes to be known to the editors when you are editing and you are seeing some mistakes that are just dampening the arguments of an author, mistakes that they could have been made aware of if they had the opportunity to. So to bridge that gap between thinking and actually communicating thoughts in an academic and scholarly manner, we brought forth the information session. Then the second purpose is for the authors themselves to understand the institution. Sometimes we notice that authors have so many questions to ask about what happens to their paper after submission, or what are the stages of review that we have and things like that. So these types of information could easily be provided to them if we have an information like this one today. Then the last one being that it gives authors the opportunity to meet with editors and editors to meet with authors, because apart from through such an initiative, every other process is blinded. Yeah. So that is the last purpose why we're having the information session. Today's presentation would basically be handled by a mixture of the editors of the Strathmore Law Review and some alumni. And the fun fact remains that these alumni who will be joining us today, the three of them were once editors in chief. And we have Cecil Yongo, who was the founding editor in chief and a Harvard alumnus, also joining us today. So it's good to have them, and it's good to have all the editors of the Strathmore Law Review involved in today's presentation. So kindly remember to turn off your microphones and to keep your videos off. I know that right now you may currently not have the rights to do so, or the options or some of those functionalities, but they will be made available to you towards the end of the session when we call up for questions. And it's encouraged that after the questions, we turn off our microphones so that our interaction can be better. Unfortunately, there won't be slides for the session. However, we are going to be giving you a refreshment, yeah, because if this is a physical event, I expect that you expect refreshment from the Strathmore Law Review. Unfortunately, we're not going to be giving you Coca-Cola and meat pie today. We'll be giving you a handout after the session, which would elaborate on all the presentations that we're going to make today. So because there won't be slides, take notes, ask questions. You can ask during the session. You can ask using the Q&A option on your screen. You can also raise your hand to ask for clarifications, questions, and all of that. Just make it engaging and interactive because this is for you, and we look forward to hearing some of these concerns that you have and hopefully give answers to them. Without further ado and without wasting much of our time, because I know that we are so eager and anxious to have this type of engagement, to engage with the editors, allow me to hand over to the publishing editor of the Strathmore Law Review for the 7th volume, Marie Victor, who will be speaking to us about the institution itself and some of the critical processes that we go through within the institution. Marie, over to you.
Thank you, Collins. Kindly confirm that you can hear me first. Yeah, okay, great. As good morning or good evening or good afternoon, depending on where you are. So I'll just dive into the brief introduction as to the Strathmore Law Review. So the Strathmore Law Review is an annual peer-reviewed and student-edited academic law journal. It is published annually by the Strathmore Law School in conjunction with the Strathmore University Press. So it is student-edited in that the students who constitute the board are from the Strathmore Law School exclusively, and these are the same students who assess and edit the submissions that we receive. It is peer-reviewed in that the process of editing we go through is consisting of internal editing and assessment by the students, as well as peer review by experts. So expert review consists of at least 2 expert reviewers who assess and edit submissions that we receive depending on the fields that they are experts in. So we do this so that we improve the quality of the papers that we get, such that at the end of the process, we have the best of submissions that we could get. It's also good to note that the Strathmore Law Review runs by a blind review system, and in our case, it's double-blinded, in which case the authors do not get to get the information as to the editors who are editing their submissions, as well as that the editors do not know the author's information whose submissions they're editing. So only the managing editor who receives submissions and blinds them, then forwards them for consideration and editing, gets to know the author's information as well as the editors. This also applies to the expert reviewers when they're reviewing the submissions, as well as the committee that will be selecting the prize-winning article. So our fellow member of the board will elaborate on the processes and what is needed for the prize articles, but we just need you to know that there's a double-blind review system in place to ensure that there's no bias. It's also good to note that the journal publishes legal academic work that's tailored to the African society specifically. And this is submissions by undergraduate students, master's students, as well as PhD candidates. So we don't publish PhD holders, though they can find a platform in the Strathmore Law Journal. And allow me finally to just give a brief introduction to the prize that we are offering for the second year running the Yashin Jill Cultural Guide Writing Prize. So this prize is awarded to the best law and society article that will come in for this volume, as well as that it carries a cash prize of $700 US. So the prize will be chosen in conjunction by the board, as well as a special selection committee. Again, a fellow member of the board will elaborate on the process. So the board selects the best 3 articles, what it considers the best 3 articles out of all submissions, and forwards it to the special selection committee, after which the committee is supposed to choose now the best of the 3 articles. And this is how we get the prize-winning article. So with that, I hope those few remarks form a good background on the Law Review as a journal, as well as a board, and that it gives a brief introduction as to the information session that we're having. So without further ado, I'll just invite Sanjna to explain the general theme for this year's volume, as well as the requirements for publication and the award.
Thank you, Marie. Good afternoon to everyone. I'll just pick up from where Marie left off and start by giving you a few benefits of publishing with the Strathmore Law Review. As Marie has explained, we do have the prize for the second time this year. However, other than that, we also have other benefits of publishing with the Strathmore Law Review. For starters, the Strathmore Law Review has been a consistent platform for 7 years in publishing high-quality academic work. So publishing with the SLR would first ensure that you get good editors from the law review who will ensure that your paper is of the highest standard possible. And our peer review process will help you improve your presentation and communication of the research that you produce. And the feedback will also help you frame your arguments better. Still on the point for consistency, the Strathmore Law Review has obviously increased its networking and now has a good and sophisticated network. And we will be distributing these articles to our networks. Therefore, your paper will be more visible in the legal academic space. Thirdly, still on visibility, our new systems of DOI and ISSN will boost the visibility of your papers on our platforms. So this newly integrated system, in fact, ranks as number 2 in Kenya. And therefore, your paper will be accessible to as many people as possible. This new system also has a way in which it generates automatic citation for your publications. So you can export that citation to suit any method that you want, which is great. Fourthly, publishing obviously boosts your status in academia. Should you want to pursue a further career in academia or research or in teaching, then this particular publication will obviously be really beneficial to you. And it generally also hones your writing skills, which is an excellent skill for lawyers to have in general. Should you also want to pursue doctoral studies in the future, then publication is a really good place to start. Other than that, personally, I think that writing and publishing puts your research into the larger conversation in your chosen field. So you'll be contributing to the conversation on your chosen area, and your work becomes more visible within the academic community itself. With that, I hope I have convinced you enough to write for the SLR. Next, I'll be moving to explaining the requirements for the publication and the specific requirements for the award itself. So before that, the theme for this year, as you might have all seen on our social media platforms, is Law Towards a Better African Society. I'll just provide you with a brief inspiration behind this theme. As we all know, the African continent faces several challenges today, such as corruption, political instability, poor healthcare, and various other problems. And the law, as we all know, can act as a powerful tool to empower change and to solve these issues. Specifically, legal academic scholarship is one avenue through which the law can impact the African society. So the Strathmore Law Review is honored to provide such a platform to young aspiring authors to address these issues in the most comprehensive manner that they can. So in this 7th volume, we invite authors to write on articles focusing on a broad range of issues and areas affecting Africa. These could be issues focused on a single area. For example, you could choose to write about commercial law, housing law, labor law, or constitutional law, or any other specific subject. Or you could alternatively look at cross-cutting issues such as law and the IT, law and society, as Marie has explained, law and decolonization, and other cross-cutting issues. This is not an exhaustive list. However, this can act as a guide to the line that you can be thinking on. Authors are highly advised to write analytic pieces instead of descriptive pieces, and I'm sure another speaker is going to elaborate on this matter further. So what are the specific requirements of publication? The Strathmore Law Review accepts book reviews, case commentaries, and journal articles. However, it's extremely important for you to note that for the Yash and Jill Cottrell Writing Prize, only journal articles will be considered. So we have a two-tier process through which this prize is going to be administered, like Marie has explained. The internal committee, that is the Strathmore Law Review Board, will only send your paper or pass your paper through to the next stage if it falls within the requirement of a journal article and if it falls within the requirement of it being a non-doctrinal research, which I'll explain on shortly. For the award itself, the best article will be awarded this prize. And the Yash and Jill Cottrell Prize submissions target submissions which are less of a doctrinal approach and take more of a socio-legal or non-doctrinal approach. So what's the difference between the two? Doctrinal research focuses largely on the law itself, the rules of the law, the sources of the law, and the application of the law. For example, some of the questions that you can ask in doctrinal research is, has a legal doctrine, for example, promissory estoppel, been applied in a given scenario or been properly applied in a particular scenario? Or another question you could ask is, what missteps in legal reasoning can be inferred from a given court decision? These are some of the questions that you can ask in doctrinal research. Keep in mind that SLR does take into account doctrinal research. We do publish doctrinal research. However, for the prize, only non-doctrinal research will be considered. So now moving to what non-doctrinal research is. Non-doctrinal or socio-legal research is more akin to research about the law itself. So this understands law in the societal context and as a social phenomenon. Some of the questions that you can ask under non-doctrinal research and socio-legal research are, for example, are law and legal institutions serving the needs of the society? Or are they suited to the society in which they are operating? What factors influence the decisions of adjudicators? Another question that you can ask is, are the laws properly administered and enforced on a societal level, or do they only exist in their black letter? Such pieces are what are considered for the Yash and Jill Cottrell Prize, should you be writing for the prize itself. With that, I hope that I have given you some context as to what the general theme is and the requirements for publication. I'd now like to invite Khalil Badbest, who's the former editor-in-chief of the Strathmore Law Review, and he's now the editorial lead at the Afronomics Academic Forum. Welcome, Khalil.
Thank you, Sanjana, for that introduction. Could you please confirm if you can hear me? Can you hear me?
Yeah, we can.
Okay, thank you. So what I'm going to take you through is the very foundational substantive requirements that are looked at during the primary review. You could think of this as a very basic checklist that you need to tick for your article to go through the primary review, whether it's doctrinal, non-doctrinal, it doesn't matter. But before I get to that checklist, I'd like to preface it by introducing what Sanjana talked about, that the analytical nature of articles that the Strathmore Review publishes. And we get a lot of articles from my experience in the law review that are overly descriptive and describe issues, could even be in a structured manner, but that doesn't matter. So the most basic requirement that your article needs to meet is it should express a thesis. And a thesis is, in simpler terms, it's a central argument or an overarching argument that your article or submission is built around. So for example, this could be criminal defamation laws in Kenya unjustifiably limit the freedom of expression and are therefore unconstitutional. So you have this basic claim that your entire submission is structured around. If you were to boil down your submission to one sentence, it should be this basic claim. And I just like to remind people who are interested in writing that submissions are usually rejected outright where they are purely descriptive, even if it's structured description. So that's a very basic requirement to fulfill. And once you fulfill that, now we can go to what I'd like to call a checklist of foundational substantive requirements. And the first of those would be novelty or originality. And basically your article, your submission should be providing a contribution to the existing body of knowledge. That means that when we look at the current research, the current scholarship, there is a gap in that research that your study is filling. Research is all about systematic inquiry. So for the findings that inquiry yields to be meaningful, it should at least be adding something. And by contributions, I also don't mean that there should be something redefining everything we know. Contributions can be in different forms, which I'll get into in a bit. But what you should note, regardless, is that the more ambitious you are, the more original you are, the more rewarding this will be. The higher your chances of publication, and at a higher level, the higher the chances of you winning the prize. Now, to get into the different forms of contributions, it could be in the form of the actual claim. Remember when I talked about that your article needs to have a central argument to claim. So it could be in the form of an actual claim. For example, the example I just gave on criminal defamation laws. If that has not been argued in the existing body of knowledge, and you do, then it's a contribution, definitely. Or it could even be a different justification for a claim that's already been made. So for instance, author A has made the argument that I've just given, that criminal defamation laws are unconstitutional on the basis of freedom of expression. But author B could argue instead that criminal defamation laws are unconstitutional because they unjustifiably limit the right to discrimination. For example, they discriminate between women and men, something of the sort. Same basic claim, but the justification is different. Or they could be supplying an entirely new perspective to problems that have been written about and claims that have been made with regard to that problem. So for example, you could be using a different theory, a different conceptual framework, which the speaker after me will get into. The takeaway is that you're actively adding something to the body of knowledge. And then I would like to say finally on novelty that it's easier for an editor to tell that your work is novel when you make an active effort to show that. This is usually something you should consider doing in the introduction, outline a trend in the current scholarship and provide where your work fits in. That's a very easy way to for the editor to infer the novelty of your work and something that will help you get through a primary review. Secondly, on that checklist would be non-obviousness. So, arguments that are obvious are those which are very clear, which are very self-evident. Now, I said that research requires systematic inquiry. But if something if there's a question that anyone can answer, or it's a simple yes or no question, then it's not worth inquiring about. It's not worth investigating about, even if you can technically fit it into a contribution or something like that. To quote one author, arguments that just apply settled law or familiar arguments to slightly new fact patterns usually look obvious. So if the arguments you are advancing in your submission are too obvious, then it's likely the case that your article won't pass through the primary review. For example, arguing that all defamation laws must be in line with the right to freedom of expression. Sorry, with the right to freedom of expression. This is not something that's in dispute. The Constitution, for example, of Kenya has been in, if you argue in the context of Kenya, the Constitution of Kenya, for example, has been in effect for around 10 years. This is not something that's in dispute. So for your arguments to be less obvious, it's advisable that you make them more nuanced. So for example, you identify a particular area of the law that you think the freedom of expression, the right to freedom of expression should apply to, but has been neglected. It's a general argument that you're applying, but in a very specific context. And so it's more nuanced and less obvious. And finally, would be the requirement of usefulness. What Sanjana told you about the theme for this volume, and I think the last volume, was Law Towards a Better Africa, or Law Towards a Better African Society. And that points towards a certain utility in your findings, in your arguments, in whatever you're advancing. So you should ask yourself, the first question is, who and why am I writing? Who am I writing for and why am I writing? Because who you're writing for will determine the impact that you want to have and the recommendations that you want to give. And recommendations, especially feasible recommendations, are one way to make your article more useful. Obviously, your article could also have utility in a very knowledge-based or epistemic sense that that people, for example, scholars, are understanding a particular issue in a particular way, but your article or submission is advancing a new understanding that will shape how these people think about that particular issue. And at a higher level of usefulness, at least in my view, and I think in the law review's view as well, you can tell that an article's findings are applicable beyond the specific case study. Like, for example, if you're studying Kenya and you're studying the right to freedom of expression, your article is going to be much more useful if we can apply your findings to, for example, Ghana or Nigeria, or and so on and so forth. So it's just a way to increase your usefulness. And finally, I would like to say that when you're writing, think about the timeliness of your submission, because this is something that the editors will consider. Current relevance is a good way to gauge how useful also your article will be. You know, does it have current implications? If it doesn't, then how useful is it anyway? And secondly, it should not be overtaken by events. Something could be useful now, but the editorial process takes like 3 months or so. So will it still be applicable? Your findings, will they still be applicable? Will your article still be useful after those 3 months have elapsed, after a year has elapsed after publication? So those are some of the things to keep in mind. And with that, I think I would like to yield the screen to Arnold Nchiko, who is an associate editor at the Strathmore University Press and also a former editor-in-chief like myself. The screen is yours, Nchiko.
Yeah, thank you. Thank you for that, Halil. Hi, everyone, and I hope you can hear me. Can someone confirm whether I can be heard?
Yes, you can.
Okay, yeah. So basically, I was told to talk to you guys about the structure of a paper, the methodology that you may take, and finally to touch a bit on the framework that might be guiding your paper. So on to the structure of a paper. As Halil was saying, your paper must have a central claim that you are making, or a central question that you are asking, or a central hypothesis that you are somehow trying to test. So now in terms of structure, you have to take us systematically, like on a systematic ride all the way to the central claim that you are making. Cecil, for example, usually explains this in form of an inverted pyramid. This is just you taking us to the claim that you are making. So basically, an inverted pyramid is like you are coming, simply put, really in a simplistic manner, from general premises all the way to the specific points that you are making. An example, let's say you're about to say the Anti-Homosexuality Act of Uganda, like a certain section, you have an issue with it. You are saying that it violates human dignity. This is just an example. But even in terms of structure, you have to take us there like somehow systematically. It can't just be like the first line to start your paper or something. We have to be taken there. So something that you can do, for example, you can say while homosexual conduct has been recognized or like has been there like for many years, it was not always welcome in the law, maybe because the church and the state were never separated and all that. And then as time went on, we are seeing a separation between the church and the state. But still, the content of the laws kept on supporting, this is just an example, by the way, some Christian values. And this was the case even like in colonial Uganda, for example. But then again, as time went by and all that, people started realizing that, yeah, the content of the laws has somehow some bias for certain value or like for a particular set of morality. This is just an example, it may not make sense. And then you're like, this is actually seen in this particular, I don't know, this particular section of the Anti-Homosexuality Act and all that, and then you make your central claim. The whole point is you're taking us systematically all the way to this point. Now, once we are there, once you make a central claim, you have to prove it. And to prove it, this is why your paper comes with the various parts that it might have. So you may be like, in part one, this is what I'm going to do. And what you're going to do, you show us somehow how it communicates to what you're going to do in part two. And what in part two is going to communicate to what you're doing in part three. So there has to be like a flow, a logical flow of ideas, even within the major chapters of your work. There has to be always a reason. So like all these chapters have to reinforce somehow the claim that you are making. They have to help you prove the claim that you're trying to make somehow. Yeah, so you really need a roadmap, though it's not always a requirement, but like a reader has to see clearly that this is the central claim you are making, or this is your central hypothesis. And this is how you're telling us that you're going to prove this claim, that you're going to test this hypothesis. So like, it can be something like, first, this paper will do X, Y, Z. Second, it's going to do this, this, and this. And third, it will do this. And maybe like, lastly, it's going to conclude. Then the other thing, when it comes to the structure of a paper, what we need to understand is that even an idea, like an idea, the way you present it within a paper should be looked at as a mini paper of its own. This is why it's usually like recommended that you should have one idea per paragraph. And within this paragraph, you should have an introduction, which is usually known as the topic sentence. And then you have the body of the paragraph, and then you conclude. And the introduction usually, still within the context of like a structure of your paper and everything, because things, there has to be a flow and the reader shouldn't be hanging at any point. Even in that introductory paragraph of the topic sentence of your paragraph, the introduction of your paragraph, make sure that for every cause that you make sure that cause is specific and that the effect is also very specific as well. Let me give an example. So if I say, for example, transnational corporations in the DRC are violating human rights. So we can clearly see that the effect that is there is human rights violations. The cause of that is transnational corporations. The effect is clear, environmental rights are being violated. But now the cause of that, we are just saying transnational corporations. Now, myself as a reader, I'm going to wonder, okay, what about these transnational corporations is resulting into environmental rights violations? So all this to say that your cause has to be clear as well. But because like someone can say, is it that these corporations are paying villagers to burn down trees? Is it that they're cutting down trees? I don't know. Is it that they are setting forests on fire? All this can lead to environmental rights violations. So like you shouldn't let your reader in such a situation. So like for every idea you present, just make sure that there's a clear cause and there is a clear conclusion. So in the example that I've just given, if you say, for example, the mining activities of transnational corporations in the DRC are resulting in environmental rights violations. As a reader, okay, the mining activities, so like, in as much as I don't know really, though I can be more specific, but then you know, like mining, it starts from this stage, it ends at this particular stage, there's a bit of clarity somehow. And unless you have that clarity, like even within your paragraphs, like the reader will be left asking questions like how, okay, what is the cause of this? And you shouldn't let your reader in that space somehow. Anyway, I can take questions on the structure later on if there are any. In terms of methodology as well. So yeah, the methodology that your paper has to take it has to be like really, really, really rigorous somehow. Because like even in proving your point, something that you're usually after is credibility and all that. Why should I, as a reader, believe what you're saying and all that? Let me give you an example. Maybe you're writing about a global problem, something like, for example, now, like the use of cryptocurrencies, the way it is being done, like in many countries. And then this is like a global problem. And then you just take Kenya as a case study or Uganda as a case study. You have to justify why you're taking this country. Because one can say, maybe it's just like favor your arguments that you're trying to make. So that has to be clear. Or like you are writing about a certain matter and then you have select case studies. So like we're like, I'm going to look into Zambia, Zimbabwe, and South Africa. Somehow in terms of like academic rigor, you have to explain to us why you are taking those particular countries. The other thing when it comes to methodology and where like most of us usually struggle is when you choose the path of a comparative analysis. So basically what you are saying is like, this is the situation in Nigeria, for example. This is how things are not working in Nigeria. But then what I'm going to do, I'm going to look at Germany because these things are working there in Germany. And Nigeria should do what Germany is doing. There's like, you can do that, of course, yes, but then you always have to justify why are you comparing? Because there are things that can be compared somehow. An example can be Nigeria is a developing country, Germany is a developed country. Nigeria is a common law country, Germany is a civil law country. But then you're saying we'll just take whatever is working in Germany and we implant that in Nigeria. Yeah, they'll be like really rigor, like lacking on, because people will tell you whatever you're saying cannot work because the realities are not the same. But you have to make a case in your paper showing us how whatever you're like establishing the measure comparison somehow, and they have to be the same. That's something else that usually comes up when one is dealing with methodologies. The other thing that even myself I'm really, really like struggling with is if you choose to conduct interviews or to collect data, to do surveys. Yeah, by the way, these are like, I think if we are to go after the Jill and Yash Guy Prize, this is something that you can also like consider looking into, specifically if you don't want your paper to be doctrinal in any way. But now, like even when we speak of interviews or like data collection, surveys and all these things, there are rules that have been established to do this. And I know that most of us can be undergrad students and we've never been taught how to collect data, but self-education is actually a thing. Just like be careful about that. And then finally, I was told to talk to you about frameworks. From where I sit really, I think other than having a really novel topic, well narrowed down and everything, the most important part of a paper is usually the framework you're using. And this can be a theoretical framework or it can be a conceptual framework. And now, like a theoretical framework, this is where you just take a theory to show how things usually work out. And I think I've given this example several times, like, yeah, so like a theory is like it's predict how whatever you're suggesting, the solution you're suggesting is going to work. Here is like a basic example, like Newton's third law, if I'm not wrong, yeah. So basically, this way it says that for every action that you apply to something, there is an equal like reaction force. That like the force that you apply to something, you get like an equal reaction force. That's like a theory that is there. And then like maybe you're trying, like the problem you're trying to solve is like car accident. And then you're saying, we need to have seat belts so that whenever there's an accident, instead of me flying forward, yeah, because the theory shows that like if I fly forward and I hit something really hard, it's going to apply to me the same force that I've applied to it. So now, if your solution is seatbelt, it's like when we get into an accident, I won't really fly forward and I'm going to avoid that. Anyway, a theory usually does this. But then something that I've seen, at least in my experience as an editor and maybe as a law student, is that many a times we don't really pay attention on the kind of theories that we use, and we really need to watch out for this. You know, like theories are usually created in a context, and that context might not fit your context. So you can't just like rely on a particular theory and then you say, this is going to guide my work in Burundi. Yet the theory was developed in Italy for a certain context in Italy, which might not be the same in Burundi. So like in as much as you go for a theory, make sure that you contextualize whatever you're talking about. And then you can have a conceptual framework, which usually like build like for yourself to just provide us like a lens through which we can understand like the argument that you are making, through which we can see like your whole work somehow. And these are things that I can talk about in details later on in the interest of time. But there are also like other frameworks, and I don't think we should be limited, like philosophical framework, I don't know, normative frameworks and all that. These are things that you can read on by yourself. So there are two questions, like what makes a paper stand out? I think everything that has been said so far, particularly Halil juncture on the novelty of the paper, that has to be like narrowly defined and everything. But for me, again, the framework is key in terms of making your paper stand out, because it really, really increases like it tells me, why should I believe you? Because the framework really supports your work. And if your framework is really shaky, like even when you're like in conferences and all that, you can really have major issues, and there are really questions that you can fail to handle because your framework is somehow like on shaky ground. And to just give an example on this, there is Ambrina Manji. She's a great scholar, I believe you know her. She spent, I think, about 15 years writing a book, 15 years of work. And then while launching the book, there's this professor, Professor Issa Shivji. He took 10 minutes to destroy the whole book because he just attacked the framework. And the framework was somehow on shaky ground, at least at his level. So that's something, again, that I think you need to watch out for. And I think it's really, really like taken very much into consideration in law review. The other thing was like, how can you fine tune a topic of your interest and all that? Yeah, so I really don't know, but my own experience has been, I get a topic, I discuss it with friends, friends who have an idea about legal research and writing. And also, I seek the opinion of an expert in that field, just to save myself time, because you can decide. Yeah, and like I really learned this the hard way. I remember this was after my first year. I'm going to second year. I've never done international law. Then I started researching into international law, and I was treating it as domestic law. Like 4 months of research. Yeah, so I think I was told, Nchiko, your paper makes logical sense, but it is based on wrong premises. So it is always good to ask. In fact, asking can spare you like a lot of time, and you can be really easily directed. Yeah, and finish up on your work. I think that's really it on my side. Thank you.
Thank you, Nchiko, for that. So my name is Peace, and I'll be tackling the technical requirements for publication, the award, and other miscellaneous issues. So the first thing that I would like us to note is that the deadline for submitting submissions and or papers is the Friday, 27th of August, 2021 at midnight, or rather before midnight, so perhaps 11:59 p.m. Then the next thing that I will be talking about is submissions that will be considered for publications. This has sort of been alluded to by Sanjana, but I'll just again give it in more details. So the first type is articles, and these are what an article is. It's a comprehensive and thorough analysis of issues related to the theme of the journal. So it's like the doctrinal, non-doctrinal, just a small example. And usually it ranges between 7,000 to 10,000 words. Then there's case commentaries. Basically from the word, there are comments on cases, but it's an academic writing that analyzes and criticizes recent cases. Usually ranges between 4,000 words. Then there's also legislative and policy commentaries. They are comments on legislature or policies. But again, there are also academic writings that analyzes recent or contemporary policy and legislative development that need review. Again, they range between 4,000 words. And again, also any other submissions, which would, for example, be normative law articles, long essays on legal profession, legal education, legal research, and legal writing itself. But now for the award, as Sanjana said, the only submissions that will be applicable for the award are articles, which I explained first. The next thing I'd like us to note is that we require adherence to SLR. SLR is a footnote reference style that gives the format and structure of how citations should be, the type of bibliographical information that should be entailed within the footnotes. And then again, as I've said, it's footnotes, so it's not in-text citation or endnotes. And a link to the SLR document will be shared on the chat shortly. Yes, then another thing that we need to note is the adherence to the SLR editorial policy and style guide, which is a guidance material that gives further instructions on the preferred format and structure of submissions. And some of the instructions include, for example, that the SLR only publishes unpublished works. So therefore, you cannot share your article with another journal. Maybe it's been published in a different journal or wherever, a book, and then you send it to the SLR for publication. Another thing that you will find within the style guide is the fact that the SLR is has open access, which means that submissions or publications are shared online and are freely accessible. It also notes that there should be no plagiarism, which again now leads us to the use of SLR and to reference our works. And then it also gives us information on technical issues like capitalization, structure and format like the font size, font type, alignment, line spacing, numbering, etc. The link to the style guide will also be shared on the chat shortly. You can copy the links and use them for your reference. I would now like to invite Cecil Yongo, who is a friend to the SLR. Just a bit about Cecil Yongo. He graduated with his LLM from the Harvard Law School, where he was the executive submissions editor with the Harvard International Law Journal. He has been published quite a lot in many places, among others. There's the Chinese Journal of Comparative Law through Oxford University Press. The paper is titled Democratic Culture and Development of Artificial Intelligence in the USA and China. He received a student prize, paper prize within the Robotics and Artificial Intelligence Law Society this year in January. He's also published a book chapter in a book called Pursuing Good Governance Administrative in Common Law, Africa, and the chapter is titled An Overview of the Framework Governing Administrative Justice in Kenya. He was also published twice within the SLR. And one of the articles is An African Law Journal, Some Reflections. Then he's also the founding editor-in-chief to the SLR. He's also a lecturer at the Strathmore Law School. And for this 7th volume, he is the chair of the SLR Selection Committee, among many other things. Karibu, Cecil.
Great, thanks, Viz. Really kind introduction there. probably super long. Okay, so 3 p.m. Okay. So my brief is to talk about the prize in specific and when it arrives at the committee, what do we look for? Or maybe even before, when you're thinking about whether to submit it. But before that, it's probably worth talking about the CPIT writing prize, because I saw a question on that in the chat section. I'm kind of involved in the setup of that prize a lot. So that prize is essentially a CPIT prize. It's run by CPIT. So what happens here is, my advice to anyone considering is to submit the article, submit your article to both the CPIT email. There's an email if you've seen the call. The CPIT email, I believe it's cpitwritingprize@strathmore.edu. That email, and also just feel free to submit the article directly to the Strathmore Law Review if you think it's worth it, so that in the event you don't win the prize, maybe your article is still good enough to be published. But to be honest, I guess you could also just submit it there. And I mean, if we think that the article is good enough to be published, we'll probably send it over, even if you don't win the prize. I think we'll just like send it over to the board for consideration. But I don't think it would harm to submit your article to both places, because we're not publishing an article. So it wouldn't go against the rule that you have to. The article should not be have been submitted elsewhere. So that's what you should do. The only link really is that if you win the prize, your article gets published in Strathmore Law Review automatically. The committee for that prize is completely different. I'm sort of involved in that one, but there's other people. Yeah, and I guess the editorial process for the Strathmore Law Review will be followed if your article is selected for publication. So it's two different things. You win the prize, then your article goes through the process towards publication. Even if you don't win the prize and we think the piece is really good, might send it over to the SLR to consider. Yeah. Okay, hope that helps. Like anonymous question, but anonymous person who asked the question. Okay, so the prize. So let me just, the basic thing is we're looking for the best law and society academic work. Law and society academic work. Some people who've spoken previously have already touched on what exactly that means. I think that for me, it means that you don't focus on the legal doctrine. Instead, you focus on analyzing the circumstances, facts, conditions, or arguments underlying the doctrine itself. I'll give you some examples in a moment. Focusing on the doctrine would be, for example, focusing on how courts have interpreted a certain article of the Constitution, focusing on how courts have interpreted a certain section of a statute, a lot of that, cases, case law, then doctrine itself, for instance, the doctrine of the doctrine of unitary executive in constitutional law, focusing on those kind of things, that would not qualify. No matter how brilliant the paper is, the prize is not set up to reward these kind of papers. The prize is set up to reward papers that sort of, they are legal papers at the end of the day because they say something about law, but the initial analysis is not law, other things which I'll explain in a moment, but not law. Majority of the analysis or argument should be on from other ideas. So let me give you examples. Could be philosophy. So it could be the philosophy underlying certain legal provisions that your argument is framed around, right? Could be it could be based on empirical work. So empirical work, I mean here data. Maybe it is data around accidents, rate of accidents occurring, or data around school-going children, data around school-going children. So data, empirical, it could be, the argument could be centered on empirical work. Empirical work here could be empirical evidence that you've collected yourself, or empirical evidence that you have found has already been collected by someone, and so you're just using it because it's already been collected by someone. Given that we're not trained to be empiricists, it's probably likely that you should be relying on already done empirical work, but if you can still also just do it yourself. It could also be survey-based work, relying on survey-based work. So surveys, I mean here, interviewing people and getting insights into a legal question by interviewing people. For example, there's a new area of law these days called psychological jurisprudence, where they do philosophy of law, well, is it jurisprudence, but through interviewing people on questions like consent. So consent, then they interview reasonable people, whoever you call a reasonable person, and then they extract insights for consent as an idea, as a legal idea, from those interviews with people. Survey-based work. Again, for empirical work and survey-based work, you just need to be careful, because if you've not been trained in this, it's very important that you talk to someone who's been trained and who understands best practices, so that you do the right thing. Also, if you're doing survey-based work, it's really important to, if you are in a university, to have University Ethics Board approval for conducting your survey, which usually takes 3 months around, at least in Strathmore, so you should count backwards. They're really serious about it, actually. Then legal historical work is also another possibility. So here we mean there are many people who are legal historians, so they explain legal concepts from a historical perspective. For instance, maybe it's the idea of the coastal strip as let's take another one, caveats, as the idea of how caveats ended up in the Constitution. You can write a historical argument on that. As always, for all these things, you remember the key concepts, or the key considerations, like you cannot be making an argument that's already been made. You must be bringing up some sort of uniqueness in your argument. So if it's, for example, how caveats came to be, you can't be saying something that's already been said in many other books. So maybe you're reviewing new archival research. You found new archival research. Maybe you went to the National Archives and found new archival research that shows that, in fact, what most scholars have said happened for the caveats to end up in the Constitution is not accurate. There's more nuance to the story, and that's the uniqueness of your study. Anyway, the point here is that legal historical work can also fit this price description. Finally, policy work, like work that is analyzing policy is also useful, policy. And then generally just society arguments, like the paper that won last year, the first paper to have won, basically. That is guilty but insane. The paper on guilty but insane. It's a good paper because it's sort of analyzing social conditions around mental health, right? Social conditions here, I mean institutions for mental health, and just those institutions and how they're organized and whether they have the capacity to do what the guilty but insane verdict aims to do. And so you see, it's not focused on the verdict itself, it's focused on the underlying conditions of the verdict. And that's why it fits the price description. And I think it was more like a society-based work than anything. Oh yeah, also technical ideas. Technical ideas here, I mean, if for instance you're writing about technical ideas, I mean like you get into a technical field and you show that the law that is applying to that technical field or where that technical field will operate is not prepared for the changes that the technical field brings. So it's easy, for example, if you're writing on AI, but AI as a technical field will bring many changes to law. So you'd center a lot of your analysis on AI, explaining that AI, the changes that it will bring, first of all. Could also apply for synthetic biology, those kind of things. Even climate change, I think, sort of could apply. So technical fields like that, you could also have the substance of your work can be there, and then the conclusion can be legal, connected to law. Yeah. So those are some examples of the kinds of works that would fit the price description. I think the rest of what you need to do for your paper to qualify are things that either the editors have spoken about or you'll find in their package. They'll send you, I don't know, things like don't make an obvious argument. So if your argument is entirely obvious, like if I can sit down and you tell me, I ask you what's your argument, and then you tell me your argument is blah, blah, blah. And then I'm like, oh, I mean, that seems pretty obvious. I'd have said that if I was asked this question. If your argument is really obvious, that's probably not a great paper. Not that your argument has to be incredibly unobvious for it to be great. It's just, the point is that these things, the other rules of a good paper apply if you want to win the prize. So it's not just that the paper should fit one of these other, should fit one of these fields or these areas. It's also that the paper is actually good with regards to the other qualifications of a typically good paper. Yeah. So yeah, I think that's what I prepared. I hope that helps. Obviously, it's kind of hard to explain all these things in 15 minutes, but I've tried to summarize it as well as I can. And yeah, I think the bottom line is the paper. The majority of the paper should not be centered around analyzing legal provisions or the legal doctrine. If the paper is like that, it does not fit the prize description, it won't qualify for the prize. Majority of the paper instead should be centered around analyzing underlying ideas, philosophy, technical ideas, empirical work, survey-based evidence, historical work, etc., around which the law is then founded on, the legal provision is then founded on. Then your paper qualifies for the prize in that scenario. Yeah, so we're excited to give the paper, the prize again this coming year. I think the first paper was really good, and hopefully the next competitors for the prize will be even better. So that's what I'll say. And I think that congrats to the SLR team. I genuinely think that this journal is run very professionally, is doing really well, and the sky's the limit. And if I was considering where to submit my work personally, I would absolutely submit to them. It's just that I've submitted to them before, so there's no, like, I don't like repeating places where I submit my work. It's also open access, which is great for your academic putting your academic work out there. And you can be assured you'll get a fair shake. They'll give you a fair shake for your argument would be seriously considered. There are many journals which they don't give you a fair shake. But I think SLR will give you a fair shake. Yeah. Ethics board, let me just answer this before I leave. Ethics board, yeah, I mean, if you're doing any work that has to do with surveys, because human beings are your subjects, when human beings are the subjects of your research, like you're talking to people, asking them questions, and you're recording answers, usually any university will make you get ethics board approval. So basically they look at what kind of questions you're asking. They'll actually read your whole proposal. So you have to prepare a proposal, then look at what kind of questions you're asking. They might also follow up and ask you some more questions, and then they'll give you the approval. And then you can go now and interview the people you were meant to interview. If the subject of your research is not human beings, you don't need ethics board approval. Which the truth is most of you will not be doing survey-based research, I don't think. So yeah. Right, thank you very much. All the best to all of you. Yeah. Oh, the prize committee, just to also help people understand, there's a prize committee. I'm one of the people in the prize committee, but like this year we had two other ladies, both of whom are at Harvard, but one Indian, one Kenyan, but she's doing a doctorate now in law. So there's a committee, and everyone reads the papers. So SLR will send us the top 3, and we all read the papers. And then everybody says what they think is a winning paper. This year there was a consensus. But in the event that there's no consensus, we'll surely have hopefully 2-1. There's a possibility that you could have 3-1 though, because we have 3. We'll figure out what to do at that point. Anyway, yeah. All right, Shelley.
Thank you very much, Cecil. I believe that the substantive matters that have been addressed have been very useful to the audience. So at this point, we'd like to move to the question and answer session. And as was explained at the beginning of the session, please feel free to raise any concerns which you may have. You can do this through typing your question in the Q&A tab below, and you can also do this anonymously. Alternatively, you can raise your hand and you'll be given the opportunity to directly raise whatever question you have. So as we wait for the audience to do this, some of our panelists can be addressing some of the questions which were raised prior to the session. So the first question is to Khalil, and it reads, if you have never written an academic paper before, where do you begin? What steps should one follow to write a good and well-researched paper? Furthermore, how can one gain good research and writing skills?
Hello, can you hear me?
Yes, we can hear you.
Okay, I didn't get the whole of the question, but I got at least where do you start? Okay, from people I've spoken to who have submitted to the SLR in previous years, it helped them to actually read, not just, okay, generally to read legal academic writing, like actual articles that have been published by law reviews. And if you're looking especially to publish in the Strathmore Law Review, there's like as everyone has said, the journal is open access. So there's currently 5 volumes worth of material for you to go through if you want to seriously write. And as you're reading, I'd advise you to first look at, like, you know, the common things. First, just apart from substance, like how to structure your arguments, even the style aspect of it, because there's a way legal academic arguments are made that is different from perhaps other writing you're accustomed to. So the first step, I think, would would be that, at least from people I've talked to who've had similar problems. So I would say read published material that's legal academic in nature, especially from SLR, and then also just start writing. There's not going to be, I don't think there's ever going to be an opportune time where everything, all the stars will align and you're going to produce the best possible paper ever in the world. So I guess just start writing. Even the submissions we receive, it's not like they're perfect from the get-go. I'm sure the authors have put in their best, but some of them require minor or major changes. So do your best, and if the paper is good enough after you've done what I've said, like Cecil said, the SLR will give you a fair shake. So that's probably where I'd tell someone to start, with actual legal academic material.
Thank you, Khalil. The next question is to Peace, again as we wait. And the questions read, does one have to pay to be published, or does one get paid after publishing? And what's the, okay, that's the first question. The second question is, what's the deadline for the peer review process, and how many people peer review your work?
Thank you, Charlene, for those questions. So the first question, no, you do not have to pay to be published. Just send your submissions and they will be considered for publication. Upon a thorough editorial process, is one paid to publish. No, we do not pay authors to publish with us. You just send in your papers, and if, again, based on merit, they can be considered for publication. However, but this is different from payment. I just like to bring in light the price that we have, but that is not payment. So do not confuse that too. When does the editorial process end? So the editorial process begins upon receiving the publications, and it goes on up until around February. So that's when all there's the internal review one, when we look at the substantive aspects of the paper as well as the technical aspects. Internal review two, again, substance and technicalities, as well as the footnotes, footnote tracking, etc. So the whole process generally runs between when we receive, so sometime in September, and we hope to publish by February, which is subject to, again, the happenings of life, and how many people work on, like how many people edit a paper. So we have panels that we divide the work. So you will find, for example, a paper is in a specific panel that has about, say, 5 to 8 editors, depending on how many papers you received. So, okay, not 5 to 8 editors, but this are senior editors, associate editors, and editorial assistants. So in totality, you might find that a panel has about at least 5, and I think at most 8. So those people work on about, let's say, a fair number of papers. So one paper will be dealt with by say 5 to 8 editors for the first process, the internal review 1, and then after that there's internal review 2, which is now specific persons dealing with a specific paper. So you might find like 2 or 3 persons dealing with your specific paper. And then thereafter there's the expert review, which was also talked about. So this goes to experts, at least 2 of them, to just ensure that you're in line in terms of the substance that you're giving us. I hope I have answered the questions. If there's any follow-up, kindly feel free to add them on the Q&A.
Thank you very much, Peace. So I see that there's a question in the Q&A tab, and it reads, what are the minor or major faults that first-time academic writers face? For example, I'm not sure this would fit in this context. Having a writer's block, how can one go about this? I think the question ends there. Perhaps Cecil can address this question.
Great. You can hear me, right? Sorry.
Yes, we can hear you.
Yeah. Let's see. First-time authors, writer's block. I don't know. Writer's block is not exactly a first-time author problem, because even really experienced academic authors still experience it as well. How do you get past it? I think for the most part, people just take their time. Like they take their time. You take a break to think a little more, to think mostly, to be fair, think a little more, just wait it out for it to go. I found that usually it happens. Like maybe I was working on a paper, which actually happened to me last year. I was working on a paper, then I around December, late November, I stopped and I just couldn't go back to it. And then I took a while, and then in sometime in January, mid-January, I just went back to it and continued. But I think it's also important not to allow yourself to be hamstrung by what you refer to as writer's block. Like if you just try and be consistent and keep going, just write something. Just write something. Try to make sure you write something, even if it's a paragraph. Momentum, I found to be very important in writing. Momentum. So, and when you get your momentum, not cutting the momentum. Momentum could mean you write something every day. Momentum could mean you write something every 3 days in a week. Consistent momentum can be very useful, and cutting it can be costly. So that's what I'd say about that. Other faults, I don't know. Like, obviously, I think the major problems are a lot of people do very descriptive work when they're new to academic writing. They do a lot of descriptive work. And descriptive work, unfortunately, especially for a journal of the caliber of SLR right now, maybe some years ago, descriptive work would get in, but these days, I don't think it would get in anymore. So you have to really try and make sure you have an argument and it's not descriptive. That's a big problem usually. I assume you know how to cite and those kind of things. So that's why I'm not, those are basic things that you should not, I don't think are worth discussing. I think the other issue I've seen is like too many things in your head, too many things you're thinking about, and you need to be more disciplined. Like you just need to be disciplined as you have to say, this is my scope and I'm going to stick to this scope. Yeah, there are more interesting questions. There are always some interesting questions that appear on the side, like, oh, that's an interesting possibility. But you need to discipline yourself and say, no, maybe you can list the question down and you will do it later, or say future researchers could look into blah, blah, but this is my question. Also the width of the question. I mean, for a paper, it's a paper. Usually papers need to be narrow, like a narrow research question, very narrow research question, very frequent problem for new people, rookie authors. Frequent problem is how wide their questions are. Like you just see, you're talking about a whole legal concept in a paper. If you want to write a good paper, you have to have a very, very narrow research question, as narrow as it could possibly be. When you become more mature as a scholar, I think you can do more generalized academic work. But when you're starting out, the big advice, even my professors gave me, is that you need to be picking very clear, narrow questions. That's what you need to be doing. So that's another big issue I usually see with rookie authors. So yeah, I think those ones are the ones I can think of at the top, from the top of my head, but maybe other people have others. Yeah.
Thank you very much, Cecil. So the next question is to Marie Victoire, and it reads, my question regards the academic bracket mentioned as a requirement. I have not heard diploma in law students being mentioned in the inclusivity of the writers. I myself am a final year student at the Kenya School of Law undertaking the paralegal diploma. My question then is, can I involve myself in the writing to be considered for publishing in the Strathmore Law Review?
Apologies for missing that out, but yes, we do publish submissions by students in the diploma in law. So generally, the submissions we publish are up to pre-PhD holders. So anyone below that level, yeah, they can submit papers to the law review.
Okay, as we wait for other questions to come in, another question again to you, Marie, which was raised prior to the session, and it reads, are authors given room to review their pieces with the guidance of the editorial team once submission has taken place, or are the articles that haven't met the parameters set discarded at first instance?
Okay, so I'm not sure I get the question in totality, but so there are different stages of review for the submissions that we get. There are papers like, I think it's Halil who said it, that if it's a barely descriptive, just descriptive paper, then I don't think it proceeds to even to the first review. But papers that get to the first review and pass the first review by the internal editors and get to the second process that Peace was talking about, where each submission is assigned to an editor, then in that stage, there's a back and forth between authors and editors. You don't know who is editing your work, but then you get comments back and track changes. So I don't know if that helps the author, but that is the kind of communication that there is that enables authors to know what their editors are thinking about their paper and how to improve it. So that back and forth in the internal review too, that's where maybe you get the feedback that you need.
Thank you, Marie. So again, please feel free to continue raising your questions. As we wait for people to raise their questions, there is a feedback form that is going to be shared in the chat. I'm kindly requesting everyone in the audience to take the time to fill this form. It will help us in contacting you after the session, and it will also be particularly impactful to us in preparing for our future sessions. You can also contact us at our email, which is also going to be shared in the chat if you have any further concerns or inquiries. So as we wait for the audience for any other pending question, perhaps we can look at another question which was raised prior to the session. Okay, so the question is to Sanjana, and perhaps maybe you can just rehash what has been stated. And the question asks, what are the distinguishing features of the prize article that was there before, and are there any particular common traits that are in previously published articles of the law review that one should look out for?
Sorry, could you kindly repeat the question?
So the question is on any distinguishing features that come out in previously published articles and also in the winning article that authors should look out for. Perhaps you can rehash this.
Okay, so specifically to answer the second part of the question, what distinguishes other journal articles from the one that would be considered for the prize? Two things. The first is that it must be a law and society paper, like Marie had stated. And the second thing, and I guess this is where the more important distinction comes in, is that it must be non-doctrinal research or social legal research as opposed to doctrinal research. Like I've stated, when you look at social legal research, you're looking at the law in the societal context. So how the law is applied to the society and how it's working or not working in a given context. I hope that answers your question.
Yes, it does. Thank you, Sanjana. Seeing as there are no further questions, perhaps we can close the session. So I'd like to take this opportunity to thank all our panelists for their valuable contributions. I'd also like to thank the law firms who are in attendance, the research clinics, schools, and the participants across the 11 countries. Thank you for taking the time to attend the session. Thank you very much, and we look forward to receiving your submissions. Have a great weekend ahead.